welcome to this FedSoc Forum webinar call. Today, March 18th, 2025, we're delighted to host a litigation update on United States versus Peterson, coming out of the Fifth Circuit. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief, certainly more brief than their careers would deserve. So I highly recommend you go ahead and check out their impressive full bios at fedsoc.org. Today, we're fortunate to have with us Michael Williams, who currently serves as the General Counsel at the American Suppressor Association. Mr. Williams first joined ASA in 2014 and served as ASA's General Counsel from 2015 to 2016 before he left to join the first Trump administration in 2017. He began his federal service at the White House Office of Management and Budget, OMB, where he served for 2 years as an attorney in the Office of General Counsel. He then transitioned to the West Wing in March of 2019, where he served as Deputy Assistant to the President and Counselor to White House Chief of Staff Mick Mulvaney. Mr. Williams left the West Wing in July 2020 to serve as Acting General Counsel for U.S. Department of Housing and Urban Development before coming back to ASA. Also joining us as our moderator for today's conversation is Robert McBride, who is currently partner in charge at the Kentucky office of Taft, Stettinius, and Hollister, LLP. Prior to his time there, Mr. McBride was an assistant United States attorney in the Eastern District of Kentucky for over 15 years. During his tenure as an AUSA, Mr. McBride served in several leadership positions. In 2006, he was assigned as manager of the London branch office. Shortly thereafter, he was promoted to criminal chief and served in that position until January 2010. More recently, he was the supervisor of the Fort Mitchell branch office, where he handled a number of high-profile investigations and prosecutions. Mr. McBride also served the United States Navy's Judge Advocate General Corps for 10 years. His major assignments included senior prosecutor in the Isle of Guam, officer in charge of a detachment of the New Orleans focusing on criminal defense, and staff judge advocate in the Recruit Training Command. And I will leave it there. A last note before I get off your screens, if you have any questions throughout the program, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screens. They'll be accessible when we get to that portion of today's webinar. With that, thank you all for joining us today. Mr. McBride, the floor is yours.
Thank you very much. I'm looking forward to a robust discussion about U.S. versus Peterson with Michael Williams. But there are a couple of preliminary things I'd like to do before we get down to the case. The first is, Michael, could you tell us a little bit about the organization for which you're general counsel?
Absolutely. So I'm privileged to serve as the General Counsel of the American Suppressor Association. We are a 501c6 trade association representing suppressor manufacturers, distributors, dealers, and the public at large that own suppressors. So, we do quite a bit of lobbying at the state level, the federal level, and we're also, through our foundation C3 side, also involved in some litigation, challenging the constitutionality of some bans on suppressors at various state levels.
Their organization is actively involved in some of the litigation involving silencers, Second Amendment, and the National Firearms Act. One of the things I've learned over time is that many of the proponents and people interested in the Second Amendment don't have an operational understanding of firearms. Could you tell our viewers what a suppressor is and very briefly how it functions?
Happy to, and you're exactly right, Bob, and thank you again. I'm going to start answering that question by telling you what silencers are not, right? So, as you mentioned, I've been advocating on behalf of suppressors for over a decade at this point. And while this perception is changing a little bit, I'd still say most of the American public, and even a lot of folks in the Second Amendment and shooting communities, when they think of suppressors, they tend to think of what they've seen in the movies, James Bond, for instance, and they imagine that this is a device that you can screw onto the end of your gun, and somebody in the office next door to you could be shooting off rounds out the window at some squirrels, and you would not know about it. It would be that quiet, like almost in the movies oftentimes they make it a clicking sound, when in fact that's just not how the physics of firearms work. What a suppressor actually is, and suppressor, silencer, people call them different things. What it actually is essentially a muffler for your gun. And when I say that, I mean that very seriously. They were invented by the same gentleman. Both the car muffler and the firearm suppressor were invented by the same gentleman back in 1909, guy by the name of Hiram Percy Maxim. He just didn't like loud things, and he invented all kinds of similar contraptions to keep various types of machines a little bit quieter. And so, what does a suppressor or a muffler do? At the end of the day, you're just exerting physics on the explosion of a firearm round. So the reason when you pull the trigger on a firearm that there's a loud noise is that what's happening when you pull the trigger is a primer explodes a bit of gunpowder, and the explosion of that gunpowder creates a whole lot of pressure and a lot of hot gases that propel a projectile out the front end of your firearm. And when those very hot gases leave that compressed chamber and enter the cold air, a lot of energy is released in the form of a sound wave. And what a suppressor does is it traps those gases and lets them cool in a compressed, contained environment a little bit before it hits that colder air. So we like to analogize it to letting the air out of a balloon. So if I have a full balloon and I pop it with a pin, it makes a loud noise because all of that energy is released very quickly. I can also let the air out of that balloon in a controlled manner and it'll be silent, right? The air will move in a slower pace, and it doesn't come with that sound wave. So again, that's what a suppressor does. And just like a muffler for your car doesn't make your car silent, it's just not going to, right? What is that silencing? What is that quieting down? That's quieting down, again, the explosions happening inside of your engine that are making that car move. It's the same exact principle here, where putting the suppressor is typically a series of baffles. So there's internal baffles or pieces of metal that catch some of that gas as it's released, and again allow it to cool down inside of that suppressor. And as I said, just like in the car, you're not making it silent. With the firearm, you're also not making it silent. Typically, and here's where I'll go a little bit into some science and physics that is kind of above my head, so please bear with me here. But um, it's important to know how sound is measured and what some of these numbers mean when I explain them to you. So, sound is measured in decibels. Decibels are a logarithmic function. So, every 3 decibel increase in sound is a doubling of the sound pressure. So, it's like the Richter scale. A 10 decibel, at 10 decibels, we're talking, I can't recall the number off the top of my head, but it's exponential growth in that sound. Um, so OSHA starts regulating sound levels at 100 decibels. And they say that once you get over 100 decibels, at 100 decibels, you are legally allowed to expose your employees to 8 hours of a particular noise before you need to mitigate that exposure. By the time you get up to 130 decibels, we've gone up so far. And at 103 decibels, it's 4 hours. At 106 decibels, 2 hours. Until we get down to 130 decibels, where employers are not allowed to expose anyone, their employees or the public, to a noise of that range. So, what are firearms? Where do firearms fit into that? Your typical 22 unsuppressed is going to come in around 130, 140 decibels. For reference, a jackhammer is about 100 decibels, 100, 110 decibels. An AR-15 coming in closer to 170 decibels. That's the amount of sound generated by an aircraft at takeoff, if you're standing very close to it. So your best suppressors on the market are going to be able to pull that sound level down about 20 to 30 decibels. So for an AR-15, we're pulling 170 decibels down to about 140 decibels. That is still a heck of a lot louder than even an ambulance siren. And again, it's a quick impulse noise, so we might not perceive it necessarily uh, as loud as a siren, because that siren is longer in duration, but it's that loud. So even on a 22, your most effective suppressors on the market are going to pull us down to about that jackhammer level of about 100, 110 decibels. So I apologize for my lengthiness there, but I think it's important to know what they are, what they're not.
Oh, I appreciate it. So the next thing I'd like you to talk about is how silencers are regulated under the National Firearms Act of the NFA, in terms of possession, taxation, and transfer.
Absolutely. So the NFA was one of the nation's first gun control bills back in 1934. Um, it what it regulates is several different types of firearms. It regulates suppressors, it regulates short-barreled rifles, it regulates short-barreled shotguns, and it regulates automatic weapons. And this was the result of some gangland violence that was going on at that time. There are also some, concerns about poaching. Suppressors likely ended up in there because Hiram Percy Maxim was a little too good at marketing. He marketed them as silent. People believed they were silent, even though they weren't. And so they got sort of lumped in with those other firearms. And what the NFA does is it requires, like I said, it's in the tax code, and it requires that before an individual purchases a suppressor, he or she has to file with the now Attorney General, that used to be the Secretary of the Treasury, an application and pay a $200 tax stamp. And if you're a person, the statute says if you're an individual rather than a trust or a legal entity purchasing the suppressor, you need to apply to the Attorney General with fingerprints and a passport style photo. And then what they do, what ATF now, who owns that process, does with that is they run just a regular run of the mill NICS check. So they take the information you give them on what's called a Form 4. It's an application to transfer a firearm, to transfer a suppressor. NICS and the FBI run that through the NICS system, and it spits out
Next,
an
I'm
answer.
sorry to interrupt you, Michael. What's next?
Sorry, NICS
Supposed
is
to
the
be on
National
that.
Instant Criminal Background Check System. So that was a later amendment to the Gun Control Act of 1968. That's your instant background check that if I go into a gun store to try to purchase a handgun or a shotgun or a rifle, something that's not an NFA weapon, uh, that's what the store is entering into this FBI database, and the FBI is coming back and saying proceed or don't proceed.
Yes.
Interestingly, unlike the Gun Control Act and the NICS system for a handgun or a shotgun or a rifle, uh, there's no 3 day shot clock. So in those transfers, the FBI has 3 days within which to either approve or disapprove of that transfer. And if they don't disapprove of it, then the sale may proceed at the discretion of the gun store. And so with suppressors, even though, like I said, they're going through that same system, uh, there is no shot clock, as it were. And so up until about the last year, those checks were taking about 9 months to 18 months in some cases, really because the FBI folks knew they sort of put them at the back of the queue. That's changed thanks to ATF recently. And now we've got those transfer times down to about 7 days. But it is, you're having to file tax paperwork just to transfer this, and the manufacturers are having to file paperwork with the federal government when they make them, and they have to file paperwork requesting to transfer it at each step in the distribution chain. So from manufacturer to distributor, distributor to FFL, and then finally you pay that tax when you purchase it from the FFL. And that also means that if I, for instance, wanted to transfer a suppressor to you and you were in the same state, you would also, that person to person, would you'd have to pay that tax also. We need to get somebody in the middle of that transfer.
So part of the NICS filing is to ensure prohibited persons like previously convicted felons don't possess the silencers, just like they can't possess the firearm.
That's exactly right. And it's that same 9 categories of prohibited persons, like you said. So felons, domestic abusers, illegal aliens, dishonorable discharge folks, anybody who's been uh, involuntarily committed to a mental institution. Those folks, we all like that they're prohibited from purchasing or
Right.
possessing firearms, and that applies equally to suppressors.
Okay. And I just know for the audience, there are criminal penalties for violations of these particular statutes, not only in Title 18, but also in Title 26. So, anything else you want to add before we start talking about the Peterson case, Michael?
No, sir. I mean, I think that about covers it. The takeaway from that I want to make sure everybody walks away with is suppressors are not silent, even though sometimes we call them silencers. And it's a decently onerous process, though, it's a lot of hoops you got to jump through, although they are very purchasable. We've got a big market and sold over 1 million last year nationwide.
Okay. Thank you. So let me give a brief overview of the facts. I'm an old trial lawyer. I love facts. So this case comes out of the Fifth Circuit. Mr. Peterson operated a company called PDW Solutions, Inc. He was an FFL, and he was operating his business out of his home. The investigation involved Mr. Peterson selling a deputy sheriff two handguns without reporting the transaction to ATF as required by the NFA. And then he sold two firearms to an agent undercover who he believed to be a straw prohibited person. So in other words, he made two straw transactions, purchases. And then he had also been operating out of his home. He kept his home, he kept the inventory in his home. But the reason this is significant is because when he filed his FFL license where he filed for his FFL license, on the jurat, he swore that he would not be operating out of his home, but rather only at gun sales and out of a leased storage unit. So the law enforcement believed that was a violation of 18 U.S.C. 1001. So based on that evidence, uh, law enforcement obtained a search warrant for his home. And among the things they found in his home was a silencer in his safe. This silencer was probably assembled from a kit because it had no registration number on it, and they could find no evidence of tax, of the tax stamp. So at the trial level, Mr. Peterson entered a conditional guilty plea to criminal violations of the NFA, as Michael has just discussed. It's important to also understand there are serious criminal penalties that come with this. So these particular violations come with a potential imprisonment of up to 10 years, a $10,000 fine, and then a term of supervised release, which in the federal system is actually part of the sentence, but it looks like probation in state court. So Mr. Peterson raised two issues. One, he filed a motion to dismiss, claiming that the registration requirement of the NFA on suppressors unduly burdened his Second Amendment rights. And secondly, he filed a motion to suppress the search based on inadequate PC. The result of that was the court found that the Leon exception of good faith reliance applied. We're not really going to talk about that issue unless somebody in the audience wants to do that. So with that, the first issue that comes up that we want to talk about is Mr. Peterson's position with whether or not the First Amendment, the Second Amendment applies to a silencer, and if so, how did the regulation burden it? So, Michael, what kind of arguments were or should have been presented on behalf of finding the Second Amendment applicable to silencers?
I can get into the arguments that we think should have been presented here. In any event, the Fifth Circuit found, against him. And I do want to make sure that we're bifurcating this, as you said, and focusing in on the constitutionality of the suppressor itself rather than the constitutionality of the NFA.
Right. Thank you.
Which are obviously separate issues. And on the suppressor front, I think there's a strong case to be made that suppressors are in fact arms and therefore covered by the Second Amendment as articulated by the court in Bruin v. U.S. We, in some of our other cases, so I'll note that, in the Fifth Circuit, there's no state that bans suppressors. So, we haven't seen an opportunity to challenge, to make this case in front of the Fifth Circuit. But to my mind, it's a three-part argument for the legality, for the constitutionality of covering suppressors. And essentially, the first and most important point there is that when a state is banning the possession of a suppressor, what they're banning is not necessarily the suppressor itself, because as I said, a suppressor is just a muffler that's applied to a firearm. They're banning the use of a suppressor on a firearm. So they're banning the entire item itself, such that the conduct of possessing a firearm equipped with a suppressor is what's protected by the Second Amendment.
So let me break that down if I could. So are you arguing that when a firearm has a suppressor on it, the entire firearm plus suppressor is an arm, is an arms, a firearm under the Second Amendment.
That's exactly right. That's exactly right. And so just like, I mean, the slippery slope that you end up going down here is if the suppressor is not an arm, and the court, I guess we'll get to it here in a second, so I don't want to jump ahead. But if the suppressor's not a firearm or not an arm here, as covered by the Second Amendment, as articulated by Bruin, is a sight also not a firearm? Is a barrel also not a firearm? There's a ton of components, pieces of firearm that aren't strictly speaking necessary to the functioning of that firearm. You boil down what's necessary to create an arm. Really, it's an explosive and a projectile. You don't even necessarily need a barrel. So could the state ban the possession and owning of a barrel or sights or a scope? We think not. We think all of, and there's case law on some of those points, though not all, because in many instances, no government has thought to ban them. But you're exactly right. It's the idea that the whole a suppressor is a component of an arm, therefore it is an arm.
So I see an analogy there with metal sights, right? Because that's functioning of the weapon and built into the weapon. But I don't see the same thing with optical sights, which are unnecessary. A lot of people have flashlights on their weapons, which are not necessary. How do you distinguish between the suppressor and the optical or the flashlight for Second Amendment purposes?
Because all of those items make the firearm more, they increase its utility, right? So again, as I mentioned, almost no components to the firearm are strictly speaking necessary. So an optical sight is not necessarily any more or less necessary than an iron sight, which is also not necessarily more or less necessary than a barrel or even a trigger. Like I said, if you think about the mechanics again, and Prime Minister Abe in Japan was murdered by a rudimentary firearm that I don't believe even included a trigger. It sort of had a push that directly impacted a primer that ignited the projectile. So, it's almost impossible to say which parts other than the ammunition itself and the projectile are actually necessary to the functioning of a firearm. You can't really define that because there's different types of firearms, there's different types of components.
If you can't, if you can't, if anything attached to the weapon falls under the Second Amendment when it's attached to the weapon, are you telling me that a strap for an AR-15 is part of the firearm covered by the Second Amendment?
I think it is. In fact, that is what allows you to actually bear the arm. Without the strap, you don't have use of your arms. I don't think the state has, well, we're not getting into interest, but there's certainly not a historical precedent for banning straps as applied to firearms. I think a ban on straps should have a hard time passing muster under the Bruin test.
Right. So let me get away from strap. Let's say I weld a hook to my AR-15 so I can hang it in the back of my door. Is that hook now because it's attached to the AR-15? I know it's ridiculous, but is that hook now part of the firearm covered by the Second Amendment? And why?
That's a great question. The hook itself, if it assists in the operation of the firearm, perhaps it assists in the storage of the firearm. I don't see why not. I mean, I think the founders intended for the Second Amendment to apply to items, and the court has elucidated this. The Second Amendment wasn't frozen in amber at the founding. Just like in the First Amendment context, nobody had anticipated X or Twitter back in the founding, right? We had printing presses, but just because it's new, it is a method of speaking. It is covered by the First Amendment. I don't see why, honestly, the hook shouldn't necessarily be covered also by the Second Amendment if it is an actual component of the firearm, right? Which does help with its storage.
So I guess one of my concerns about that theory is that it's a never-ending, sort of a rule that is swallowed by the exception, or maybe a better way to put it, it's a rule that has no end. Anything you put on your firearm is then, covered by the Second Amendment. If I have a pouch on it and I stick LSD in that pouch, is that covered by the Second Amendment?
The pouch, perhaps, probably not the LSD. I'd have a hard time
Okay.
getting to the LSD. The pouch, though,
And
perhaps.
how is LSD in the pouch any different than, say, a few cartridges in the pouch?
Well, the cartridges themselves would very clearly be covered by the Second Amendment, and that's contemplated by even some of our early case law here. Um,
Okay. How
they
about
they are.
baking? How about if I have baking soda in the pouch?
I'm not sure that it would make the baking soda necessarily covered by the Second Amendment.
So there
The
are
pouch,
some
though,
limitations. All right.
there would have to
So
be. These are great questions. I've never thought to push it uh, this far, but you do raise good points. I do think, though, that in this construct, and this would apply. It applies to magazines. All of these are live issues right now. It's worth
sure.
noting. The magazines, some of the feature bans across states, so pistol grips, even back to some of the uh, uh, bump stocks or bump stocks may be a bad one, but pistol braces. Um,
Yeah. So can I back up? So one of the things you said in the beginning was everything attached, essentially, for this purpose, is a firearm under the NFA. Now, what happens when I take that silencer off and I stick it in my safe, like Mr. Peterson has? Why is that still a firearm protected by the Second Amendment?
I think it's still an arm, and important here to note the difference between arm and firearm, right? Because the Second Amendment does cover things like knives. It needn't be actually a firearm per se, but it is a component of a firearm, and firearms are a category of arms. And why is it still a component? Because just because I've taken the firearm apart doesn't mean any of the components become less a part of that arm. So, right, if the state still can't ban the trigger. I don't think the state under the Second Amendment under Bruin can't ban a trigger even when I've taken it apart and am cleaning it, for instance. Right? They can't and shouldn't be able to ban the sale of that trigger, though it is still covered by the Second Amendment. Obviously, you can buy an AR-15, for instance, in parts, and I see no reason to assume that just because it's not at that moment a part of the firearm that its use and availability for purchase shouldn't be covered by the Second Amendment.
Um, so Peterson raised this first component of your argument in the scope of the Second Amendment. Would you agree where that properly fits?
Yes,
Okay.
yes, we and yes.
So the second thing I want to posit on this then is, um, do you think, is it or is it not an expansion of the scope of the Second Amendment to include a silencer? In your opinion, if so, why? If not, why?
I'm not sure it's an expansion because I think the Second Amendment, as articulated by Bruin, applies to items that were not historically or traditionally regulated at the founding or at the time of the ratification of the 14th Amendment. Um, so I think it would be judicial acknowledgement of, judicially speaking, yes, it would be thinking about it just as a right, no, I think that suppressors are currently covered by the Second Amendment, though the courts have not recognized that. So I think it would be an expansion, judicially speaking, as I have no case law to point to, prior case law to point to that says where courts have found that suppressors are in fact arms and therefore covered by the Second Amendment. But suppressors are not unique in that bucket because I think we're post Bruin, the courts are still interpreting some of these other items that we've discussed here about whether magazines of a certain capacity are in fact arms covered by the Second Amendment. And in fact, it wasn't until 2014 that the Seventh Circuit decided that uh, shooting ranges are also protected by the implication of the plain text of the Second Amendment. So, I don't think that, to my mind, that's not an expansion of the Second Amendment. I think that's an acknowledgement, judicial acknowledgement of what the Second Amendment does cover.
So let me switch gears a little bit. We have a question uh, from one of our viewers that leads us to the next section, um, which is it's posed this way, and I'll read it just for simplicity. How much does an accessory need to facilitate armed self-defense in order to have it fall within the plain text of the Second Amendment's protection? We've touched on this a little. E.g., ammunition must be protected because it is vital to the use of firearm. How far down the scale do you go? Scopes, suppressors, holsters. We've talked about that. The follow-up question, though, is uh, does Miller apply to the established to suppressors under the Second Amendment argument? Do you have an argument there? We talked in our prep. We talked about Miller, which deals with accoutrements, gunpowder, lead, cartridges. What are your thoughts on the application of Miller here and related accoutrements?
I think it absolutely applies. I mean, these are accoutrements. These are, you know, a suppressor makes firing an arm more safe. And that actually does get us to a great point, right? That gets me to the second argument that I think needs to be made here, which is that suppressors do perform critical functions in the use of firearms for self-defense and other purposes. The suppressor itself. So, as well, I'm not even really going to distinguish it from straps here because I don't think that's crazy. But a suppressor, imagine that you're in a self-defense scenario, home invasion, and there's a bad guy in your home. If I am firing at that bad guy with an unsuppressed firearm, I'm I'm doing several things. One, I'm immediately losing my ability to process and locate sounds, and I'm also doing damage to the hearing of my family. So, as I mentioned before, firearms are loud. They're really one of the loudest items you can legally be exposed to in the United States. You're just not going to find anything else that's going to expose you to um, noises at the level of 170 decibels for an AR-15 or 150 decibels for a handgun. That is, according to OSHA and according to generally accepted practices of audiology, sounds at that level, it's not a question of whether you're damaging your hearing permanently and irreparably every time you're exposed to that. It's to what extent are you damaging your hearing? Um, a suppressor allows you to actually use that firearm and again, in a self-defense scenario, you're not taking the time to put on earmuffs or earplugs, which are, commonly on the other side pointed to as the things that make suppressors not necessary for using a firearm safely. Um, they're just not applicable. They're not even, most hunters don't even put on earplugs or earmuffs when they're taking that shot. They'll think to themselves, well, it's just one shot that I'm taking. It's one shot at 170 decibels. You do that 100 times over a lifetime, a few to a year for 50 years. You have a far lower sense of hearing. You've really damaged one of your five senses. And it's in a way that we wouldn't typically accept if it were one of our other senses. If shooting a firearm caused you to get a little bit more blind every time you did it without, a suppressor, it's not, I don't think many people would take that risk very lightly. So that's a long way of saying, um, suppressors are in fact vital to exercising this right in at least a safe manner and in a way that doesn't cause irreparable damage to your hearing at the time you do it and also to the hearing of your loved ones.
Well, if the argument is that the suppressor is part of the improves the use of the gun or the safety of the gun, is there an impact on ballistics, negative or positive, with a suppressor? I know it used to be that suppressors were considered to have a negative effect on the ballistics of whatever the round is. Can you
That's a
address
great point.
that?
Absolutely. And thank you for raising that point. That is a great point. So, back in the 50s, 60s, even up to the 70s, a lot of suppressors on the market used internally a series of wipes. So, it was actually little pieces of rubber or some sort of other material internal to the suppressor that did make contact with the projectile as it was exiting the barrel. And those could, maybe give you a few extra decibels of reduction. But because there was added friction, you were really lowering the muzzle velocity at exit of that projectile and negatively affecting accuracy. Today's suppressors, almost none of the suppressors I'm aware of commercially use wipes internal, right? So what's actually happening is you are increasing the speed of the projectile at exit because that projectile is in a controlled environment for a little bit longer. And you're also significantly reducing recoil, uh, which aids with accuracy. And you're reducing the flash at the end of the barrel. So you're really throwing the suppressor on the end of a barrel is increasing velocity of the round, and it's also making, typically speaking, once you get used to the feel of the firearm, you're likely to be more accurate with the suppressor than with an unsuppressed gun.
So we have a question from one of our viewers, and I'm interested in your view on this. So the question is, the Army has moved to issuing suppressors to regular troops. Does that lend support to your argument that a suppressor is an accessory? And he, in this case, is thinking of the XM7 and the XM250. That almost moves to the argument, in my view, that it's an integral part of the firearm. But please address the question.
I think that's exactly right. And I do want to make sure I make the point that, in our view, they're not, and in my view, they're not accessories, they're a component. And I think you're exactly right. The Army moving towards that. And it's worth noting there, too, that uh, tinnitus and noise-induced hearing loss tend to be the top three disability related items that our veterans come out of the military service with. It's one of the biggest expenditures of the VA in terms of helping our nation's retired warfighters, because so many of our warfighters have been exposed to a whole lot of unsuppressed rounds, and the Army and the military more generally is starting to come around to that idea, and notice that the best way to mitigate that is not with earplugs or earmuffs, which many of our men and women under arms don't tend to use when they're out in the field, uh, and instead mitigating the noise at the source, which is what we do with most other very loud noises, like I said, with cars, with heaters, anything like that. So I think that does go a long way. It also goes towards showing that they're in common use. And in fact, there are over 4.5 million of these items in circulation nationwide, and there will be, another million if and when the Army and Marines end up procuring these and putting them on the ends of our men and women's service firearms.
Oh, I think we've exhausted that second point for now. Let me get to a third question. Under Zell versus Chicago, coming out of the Seventh Circuit, that case says firing ranges are covered by the Second Amendment by implication. Your argument is essentially that a suppressor is an arm covered by the NFA. Can you fit, or does a suppressor fit into the rubric set out in Zell versus Chicago?
I
And
think
how?
absolutely it does. I think it does. So, if a court were to find that we, you know, rule against us on our first two arguments, we think that as a third and final backstop, we fit very neatly into Azell, where the court in 2014 held that even though the Second Amendment makes no mention of firing ranges or practicing with arms, right, not in the text, right, the text being a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, right? There's no mention of really specifics there. And again, they just mention arms. But the court there held that the right to possess firearms for protection implies a corresponding right to acquire and maintain proficiency in their use, and that the core right wouldn't mean much without the training and practice that make it effective. And it would be my contention that suppressors are similar to firing ranges and that they facilitate the exercise of the Second Amendment right. Again, for many of those same reasons that I articulated earlier, which are they're helpful for a lot of shooters. You don't just want to think, when we're thinking about what's covered by the Second Amendment, we don't want to just think about, your typical able-bodied, I don't know, whatever that is, 5 foot, 10 inch American man, or 5 foot 8-inch American woman. They're shooters of all shapes and sizes. All of their rights mean something also. And for smaller shooters, especially, an unsuppressed firearm it's both very loud and also tends to be the kick is something that matters a lot more if you're an 80-pound person than a 200-pound person. The suppressor does an excellent job of mitigating that kick, that recoil, and does allow you, and also allows people with who are on certain medications which make them more susceptible to hearing loss. That includes some blood pressure medications and also uh, you know for instance, Viagra, medications like that medically result in an increased likelihood of hearing loss from noise exposure. And suppressors are the most effective way to mitigate that and allow them to exercise their Second Amendment rights safely.
So are there any limits on that? If the court says, well, firing ranges are fine, why can't you, say you got 5 acres of land, why can't you uh, shoot practice with your firearm on your own land, even though it's prohibited by your HOA or what have you? What's the limit here on this?
Well, and that's where we get into the interesting discussion we haven't quite hit on yet. I mean, we wouldn't be making the argument here. I think one of those limits is that suppressors, even if the court were to acknowledge that suppressors are arms and therefore covered by the Second Amendment's protections, that doesn't mean that just any old person would be able to purchase them, right? The court has held that the Gun Control Act is constitutional, right? It is acceptable to, carve out 9 categories of persons who, as we mentioned earlier, who are not allowed to possess or purchase or own firearms. And suppressors, if they're covered as arms, would fall into that same rubric. So it's not to say it would be just a complete free for all. It is worth noting that in some countries in Europe, guns are highly regulated, difficult to obtain, but suppressors in some cases can be purchased just over the counter at a hardware store, right? No questions asked. And that is the interesting part here, right? That according to federal law, Title 18, these are treated as firearms. And the NFA also calls them a firearm. Um, Even though in and of itself, it would be difficult to hurt somebody with the suppressor. You could use it as a club, perhaps, but when attached to the firearm, which is what these legislators and regulators are doing when they prohibit or place restrictions on suppressors, um, it is still covered by the Second Amendment. So the Second Amendment itself allows for some limitations, and we think that suppressors, as covered by the Second Amendment, would also face some of those same limitations that are acceptable in other contexts and for other types of arms.
Is it your position that fully automatic weapons should not have the limitations of the NFA? Short barrel rifles and shotguns. It's your position that's the same as the silencer.
I won't go into my personal feelings on this one. Well, I'll
No, I
represent the
understand.
American
I want your
Suppressor
legal
Association here.
analysis. I want
Sure.
your legal position on that.
Absolutely. I think so. The short barrel rifle and the short barrel shotgun is very interesting. There's a live Seventh Circuit case that just came out, I want to say last week, where the court there held that short barrel rifles and short barrel shotguns are not arms as defined by Bruin and therefore as covered by the Second Amendment protections. I think that's going to be it's going to be a very difficult opinion to withstand scrutiny as it goes up. Hopefully it does go up for further review. When it comes to, I want to bifurcate there, I suppose, the automatics. So the automatics probably fall into the dangerous and unusual exception to the Second Amendment, as articulated by the court in Heller and McDonald and Bruin. So there are some limitations, and I think it's generally the case that if a case on automatics were to come before the court, automatics are difficult to use. They're difficult to use safely. It's possible that the court would decide that they are in fact, and I believe it was in Heller that the court, sort of put automatics almost in that category themselves, though in dicta. Um, with respect to short barrel rifles and short barrel shotguns, and I think you're going to have a hard time arguing that they are either dangerous or unusual, and the court requires for them to, if under the court's standards, the item would need to be both dangerous and unusual to be excluded from Second Amendment protections. I don't think short barrel rifles and short barrel shotguns are likely to be found to be either dangerous or unusual. There are hundreds of thousands, if not millions, of short barrel rifles, short barrel shotguns out in the public. You can purchase one, by going through the same tax stamp procedure, same application procedure that you use to purchase a suppressor. And they're just not they're not any more or less dangerous than your typical rifle. And in fact, they were only included in the National Firearms Act in 1934 as a way to ensure. So originally, the NFA applied also, and some of its original forms before it was passed, the draft bill language would have applied the $200 tax to handguns as well. And thanks to some lobbying back then by the NRA at that time, handguns were stripped out. And the best available evidence suggests that the inclusion of short barrel rifles and short barrel shotguns were there as a way to make sure nobody could get around the tax. It was effectively a ban because $200 back then equated to about $4,400 in today's dollars for items that cost $10, $15. They're very cheap.
It seems that the concealability of those items was an issue, which, states like Kentucky, where I am, you have universal concealed carry as a constitutional matter, seems to erode some of those original arguments. Uh, we've got a
Not
couple
very
of,
concealable. Hard to conceal even a short-barreled rifle, as you could probably do it under a trench coat, but
I understand. Well, they had dress codes back in the 30s, more so than today. So we got a couple of questions from our audience here. The first one, which I think is a good practical question. If we say that each part of a firearm is an arm, then could ATF assert that you must fill out a 4473 to get a background check for each part?
so interestingly, with some suppressor parts, that's already the case because the definition of um, firearm silencer or firearm muffler, currently in 18 USC 921 A25 says that the term firearm silencer and firearm muffler means any device for silencing, muffling, or diminishing the report of a portable firearm, including any combination of parts designed or redesigned and intended for use in assembling or fabricating a firearm silencer, and any part intended only for use in such assembly or fabrication. So that, you know, I don't love that definition at all. And in fact, I'd love to see it changed. But, sadly, that is already the case.
So
There's
technically they could. If they wanted to go hyper enforcement, they could.
They do. I'm not even going to say could. They do. You can't buy a part of a silencer. And in fact, this becomes a problem with repairing silencers. But yeah, I can't buy some parts of silencers if they fit, unless they have a dual use and therefore are covered by the exclusion. Uh, well, right. So relevantly, the statute says intended only for use in such assembly or fabrication. So a part that does not have a use outside of the silencing, uh, if if that part fails on my silencer or my suppressor, I do have to pay the $200 tax stamp to
I think
purchase a new one.
the question is about how far do we expand that? So if I bought a barrel, could the ATF aggressively go after that? If I brought a trigger assembly, could the ATF force us to require that under your theory that anything attached or to be attached to the weapon, pardon me, the firearm, is an arm under the Second Amendment?
And my argument would be yes, if Congress made that statute. I mean, that's the case we find ourselves in as applied to suppressors. So,
Okay.
we're already in that world. I see no reason that I can see plenty of reasons why they shouldn't. And, it gets us to our second question, which is the NFA itself constitutional? But, assuming for the sake of this argument that it is, yeah, I mean, unfortunately, there's a long history for at least the last 91 years of ATF doing just that. So they could, sure, with barrels.
Yeah. Oh. one more question that I think we may not have time for anymore. And the question is there any prospect of getting suppressors removed from the NFA completely rather than considering them either a component of a firearm or an arm?
Yeah, so importantly there, you got to bifurcate between whether they're regulated and whether they're covered by the Second Amendment, right? So, uh, you know, yes, I think it is possible. In fact, there are several different pieces of legislation. We at the Suppressor Association backed the Hearing Protection Act, which would remove suppressors from the NFA and make them fall under the Gun Control Act, and so therefore be subject to the NICS requirements. There's another bill called the Shush Act, which would remove them from all sorts of legislation. They would it would be just something that you go buy at the hardware store. It wouldn't be covered by the Gun Control Act. You wouldn't need a background check for it, and it would be pulled out of NICS. So, is it possible? I think so. There's a lot of work to be done there, but it is actively under discussion. Is it going to happen this Congress? I don't think so. But never say never. Never say never. And it's certainly something we work on.
So let's have a little more discussion about, firearms. You've seen these pardon, not firearms, but suppressors. I've seen these videos where people will take a Coke bottle full of water and shoot through it to suppress some of the noise. In your view, is that is that a suppressor that's covered by the NFA?
Not just in my view, but in ATF's view. You can absolutely be prosecuted for that. And we would go back to that definition, which is exceedingly broad, where, according to 18 USC 921, any device for silencing, muffling, or diminishing the report of a portable firearm. There's no limitation on how much. It's and any device in any amount. So, people have been prosecuted for that.
Interesting. We've got another question from a viewer, and I'll read it. First part of the question is it true the effectiveness of suppressors diminishes with use? And if so, what are the legal implications? For example, would you need to purchase a suppressor more often? And does that increase the burden of the restrictions vis-a-vis the Second Amendment?
It's a great question.
Yeah.
Typically, they don't diminish with use, although it depends on the suppressor. I mean, like any other component of an arm, they can get gummed up. There's a lot of soot and sort of buildup and chemical accretion that can happen over time inside the baffles, as you might imagine. Some suppressors you can fix that because by taking them apart and cleaning them. Other types you need to clean the whole thing. They're not able to be taken apart, but you can put them in solutions of various types to try and get some of that soot and grime and debris out. So generally speaking, it's not unlike those earlier suppressors we talked about before that had the wipes where there was sort of a limited useful life of that item. Most suppressors manufactured these days can go a long time. They're going to have an absolute life. Uh, now how, but it's long. It's more than you're probably going to be putting down barrel, especially when you start thinking about a single round of 223 costing you 50 cents a piece. How does that impact the NFA itself? I mean, the downside of the regulatory regime as we've lived it for the last 91 years is that, yeah, once the suppressor is so far gone that it's unusable anymore to the extent you get there, you got to go through the whole tax stamp purchase process, which, like I said, I don't want to say that it's a hard process. There are some distributors who make it a lot easier through online submissions, but it is, I think, unreasonably burdensome as a process.
So we have another question which I think follows on that, and it's some suppressors reduce report minimally. Are there any arguments to be had with regard to the definition of sound suppressors as unworkable?
So if I'm hearing that question correctly, are
Flash
they saying like,
suppressors.
pardon?
Flash suppressors, pardon me.
Oh, flash suppressor. Sorry, repeat that one again.
I'll read it again. Some flash suppressors reduce report minimally. Has
Mm,
this been
gotcha.
raised to argue the definition of a sound suppressor is unworkable, since presumably they're covered too?
Flash suppressors, yeah, I mean, that gets tricky. If it does in fact reduce, then ATF, could have an argument that that is a suppressor, a silencer under federal law, and therefore subject to the $200 tax. Um, to my mind, that does get to the absurdity of the definition as it stands, right? There is no threshold. I guess on some level, it's not arbitrary because any amount of noise reduction qualifies, but it is a very low threshold theoretically, and that is a problem that could potentially jam someone up.
And going back to your earlier discussion about the nature and effectiveness of silencers with respect to reducing decibel levels, I guess the question really boils down to should there be some definition or some sort of criteria within the definition to make it workable?
I think so, absolutely. And I didn't even get into the fact that uh, you know it's really only if it's intended for reducing the sound of a firearm, it could fall under that definition. Um, so should there be clarity on the definition? Absolutely. I think there absolutely should be. And there are some bills that would work to fix that definition and make it more workable. I'm thinking the Parts Act as introduced by Representative Lugar.
Narrow that scope. So flash suppressors that is a collateral issue have some sound suppression don't fall into that regulation. That makes perfect
Exactly right.
sense.
Exactly right.
So in 2 minutes or less, Michael, can you give us a summary of where you think the jurisprudence on Second Amendment vis-a-vis silencers is going?
I'm hopeful that the court, several circuit courts, and ultimately the Supreme Court will find that suppressors are in fact arms as defined by Bruin and Heller and McDonald, and that they are therefore subject to the protections of the Second Amendment. Um, I'm hopeful that will happen sooner than later. We've got an active case in the Seventh Circuit. There's a pro se litigant out in the Ninth Circuit where he lost the civil case. He challenged the constitutionality of the ban in California. He lost at trial. And when he went to appeal, again, pro se, handwritten, the Ninth Circuit there said they were contemplating appointing pro bono counsel because they wanted to hear it litigated professionally. And in fact, now the A team is out there running point on that in terms of lawyers. So I'm very hopeful that we're going in a direction of seeing sooner than later the Second Amendment's protections applied to suppressors.
Great. Thank you, Michael, so much. I'm going to turn this over to Kayla for any last minute administrative mop up. What
I
did I
will.
miss, Kayla?
Nothing at all. I'm just going to echo those thanks. Really appreciate you, Mr. Williams, Mr. McBride, for your valuable expertise and insight and you sharing this portion of your afternoons with us. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.